Hey there. So I'm out with this bonus video which I had not planned for. But the question that I put across to you all in my last video got me thinking that in how many ways a storyline can get developed between our actors, assuming the plot remains the same. The plot being there is a pandemic and there is a patented product. Our actors are the first actor being the patentee, the second actor being the other industry players, could be potential licensee, could be potential infringers, and the third actor being the big boss, the government. Now let's try building storylines from the perspective of each of these actors. Starting with the patentee. The patentee needs to ensure that the invention is worked in India and the reasonable requirement of public is met. Basically, there is enough for everyone at a reasonably affordable cost. Now this can be achieved by patentee on its own or by means of collaboration with other parties by way of issuing licenses or by way of issuing manufacturing contracts or any other mean. There could be a number of ways of achieving this. But the end objective is to ensure that everyone is happy. Now there is always somebody who is trying to take advantage of our work. Here comes our second actor, the other industry players, who may want to have a bite of the market during such testing times. They may start using the invention in its pure form or with certain significant, insignificant modifications, improvements or changes. Now if we have enough supporting documents as evidences to prove that this is an infringement, then we can term this activity as a patent infringing activity. What happens next? So as the usual course of action, the patentee is going to play hardball. The patentee is going to enforce the patent rights, trying to push a license based on the terms and conditions which could favor the patentee, and if nothing works, goes for a court case. Now while the court case goes along, as a template move, the patentee is always going to ask for a temporary injunction, which is a pretty hard blow to any industry or any business if awarded. Therefore, a lot of parameters are considered, a lot of things are considered before awarding such an injunction. But going back to our assumption that patentee was able to manage the reasonable requirement of people during the pandemic or during such testing times, the courts are going to rule in favor of the patentee in terms of granting a temporary injunction. Now, at this stage, the other industry player, the second actor, is going to be gutted because he's asked to stop his business. He's asked to stop all the activities related to his business. If investments were made, orders were taken, or supply chain was established, then it's going to be a pretty big blow to the second actor, which the actor would find difficult to emerge from. But the case goes along in terms of arguments, in terms of various procedural requirements that need to be met. And the second actor can still fight the case by going for invalidity of the patent itself. We have post-grant oppositions, we have revocation proceedings that can be opted for invalidating the patent. But then it's a long haul process. For the time being, the inventor has won, basically the patentee has won, and the second actor has to bear the losses. Now let's discuss, or let's jump to the other side of the fence and build a storyline from there. Starting with an assumption that the patentee was not able to meet the reasonable requirement of people or was not working the invention in India. And it's quite possible because during pandemic it would be difficult for any single party or a set of licensee to manage the requirements, manage the supply demand that would be tremendous because the pandemics are pandemics, right? You cannot predict what kind of requirements are there. So there is all sort of possibility that the patentee may be falling short on that mark. During such times also, the second actor may try to get a bite of the market, but with an intent of helping people at large and may start using the invention. Here also, the patentee may play the hardball, pushes for the patent rights, pushes for the licenses, and may file a court case. Usual, again ask for temporary injunctions. But considering the situation that they are going in, and considering the fact that the patentee was not able to meet the public requirement, the courts are not going to grant injunctions. because such an injunction would further worsen the situation in terms of meeting the public requirement. So a temporary injunction will not be granted. This could be considered as a softer win for the second actor and a softer loss or a grave loss for the first actor. Why? Because the market share is divided. There are two players now using the same invention, one being the authorized owner, another one being the unauthorized worker of the invention, right? So the market share gets divided, the profits get divided. So there is a little loss that can be attributed to the first actor here. On the similar scenario, the second actor can also opt for compulsory licensing, can approach the controller citing that all the reasonable requirements are not met. And again, the compulsory license will be granted. And on the terms and conditions, which would again favor, which would of course try to benefit the patentee, but then these terms and conditions cannot be compared with the terms and conditions that could have been achieved by a voluntary licensing without involvement of government or without involvement of the controller or the high courts, right? So overall, I would say these two situations would lead to loss to the patentee, the first actor. Now, what about the third actor? When do they come into picture? So the third actor come into the picture when, of course, the patentee is not able to manage the public requirement and the government is of the opinion that a CL should be granted. So CL gets granted, and so a notification is issued that any person interested can come and obtain the CL. Again, the second actor can come along and obtain the CL on the terms and conditions which are much more favorable than it could have been during the voluntary licensing. So here also the patentee is on the weaker foot, and he cannot even play hardballs, because the more rough he plays, the more things go against him. As a last resort, not the last resort. In fact, government can also use the invention for their own purpose. Again, the royalties and remuneration are decided between the government and the patentee, and High Court also can come into between. But remember, these royalties and remuneration cannot be compared with any royalty and remuneration that could have come by direct licenses. So all in all, I would say if the government get involved, it's a loss case for the patentee. Now there is another provision available with the government, that is to revoke the patent under section 66. Now this could lead to, now why revocation? Because the mere presence of the patent or mere the working of the patent itself is prejudice or injurious, let's say, to the public health, and it should not have been there. So the government can just issue notification, have some sort of hearings, and then the patent gets revoked. Now, what is this situation then? This is a permanent loss because the exclusivity is lost forever. The patent is gone forever. So it's an absolute loss if you were to term that for the patentee. So we have these storylines to work along. Which one do you think is the best possible scenario? Now we need to take care of two actors here. Not two actors, but the two aspects here. Public requirements and public interest has to be taken into account, but the inventor's interest also have to be taken into account, because these are the inventors who are coming up with the inventions. So we need to make sure that they are encouraged. They are not always pushed to the corners when there is a need, right? They also need to be dealt with properly. So I would say a lot relies on the innovators also. The patentee should take into account or should be cognizant of the underlying situations, of the scenarios that are around us before playing hardball. He should be ready to let go a bit. He should be ready to compromise a bit on terms and conditions for a license, and should always look forward or always look ways to have a license instead of compulsory license, because around such situations he can drive the point. Because once it goes to the controller level or once it goes to the court levels and the government levels, we know that the soft corner is always on the other side of it, considering there is a grave public demand. And in fact, another thing to note here is, if the inventor or the innovator were to be prudent about the conditions which are there, they can come across as people who helped the industry, who helped the public at large through such testing times, and can of course generate a lot of goodwill, which can later help them to derive benefits or derive some sort of damages, royalties, and remuneration later on from the courts, because a lot of soft corner would get developed get developed due to the goodwill gestures that were shown by the patentees. So these are what my speculative thought processes are. What do you think? Which one would you prefer, considering the overall scheme of things and overall actors in mind? Take care. Bye-bye.